Orthodox, and I appreciate you bearing with me, although you're compensated with a day off. What we're going to talk about today, what I'm going to talk about today, is the role of interest groups in Supreme Court decision making. And we've talked about this a little bit in class, in particular, outside groups' role in agenda setting. But here we're going to talk about how groups participate, whether they participate, and whether that has any effect. And we'll actually talk mostly about the descriptives of interest group participation in lieu of talking about the types of effects that they have. So let's jump right in. The first question is whether or not they even matter. We know that they have influence at all levels of electoral politics, right? They donate to campaigns. They actually help write some of the bills that congresspersons pass at all levels, state, federal. They testify in front of Congress, in front of whatever other agencies. They help bureaucrats decide what rules to make. They have all sorts of influence. Of course, people sort of hate lobbying groups because of this. The question is, what role do they play in the judiciary? The reason is, most people in the judicial system are not elected. They don't actually draft legislation, right? It's sort of, they craft it themselves via the bargaining process, as we discussed recently. And they implement their own rules, so they sort of don't need this hand-holding that some of the other political agents do. The short answer is that interest groups primarily use the judiciary as sort of a tool for their own policy success. So the way that the interest groups use the judiciary is sort of no different, or the reasons why they use the judiciary is no different than why they use the elected branches. There's basically four ways that interest groups can get involved in the judicial process. Okay, and we'll talk about, I'll list the four and then we'll talk about them in turn. The first is they can bring test cases. They can sponsor cases. They can do this thing called intervention. And fourth, and probably most notably, because we've talked about it several times throughout the semester, is that they can participate using amicus curiae briefs, right? Friend of the court briefs. Again, we'll talk about these in turn. So let's start with bringing a test case. One of the most obvious ways to participate in the court system is to actually be a litigant, right? To be a party to a case. Interest groups do this a lot. Another thing they do a lot is they find potential litigants. So they either are the named party to the case or they find the named party to the case. In other words, they can file a lawsuit or they can file a lawsuit on behalf of somebody who agrees. Standing to sue is important here. That's why they might not always file a lawsuit in their own name. They might not have standing to sue, so they go out and find somebody who does have standing to sue. We've talked about standing a little bit, not too much. So if you have any questions about this, we can discuss it later on down the line. One famous example is in 1954's Brown v. the Board of Education. The NAACP's Legal Defense Fund recruited the litigants in Topeka. So it wasn't just Brown. There was some other people, and there was other litigants around the country. And the NAACP recruited these folks because they were good candidates to sort of bring this suit. So the NAACP itself wasn't able to bring a lawsuit. They weren't affected by school segregation. They were adults. So they recruited people who were affected by it. This is kind of the most obvious instance of when groups are unable to achieve policy success through the traditional means, that is, through the elected branches. They go to the judiciary. Okay. The second way to participate is sponsoring a case. This is actually really similar to a test case, but the group isn't actually part of the litigation. So they're neither part of the litigation nor do they sort of find a person to be part of the litigation. What they do is they provide attorneys, staff, all these other resources to the litigant that they want to back. What the sort of difference is that when they sponsor, the group joins once the litigation's already underway, instead of being a part of it from the beginning. So a test case, they build it from the ground up. When they sponsor it, they sort of jump in already. So they jump in when it's at an appellate court. The reason they wait until it's in appeals is because they want to know what the outcome was. If they're satisfied with the outcome of the district court, they wouldn't get involved. Right, so what they do is they look for target opportunities to take over cases that are already underway that fit their agenda. So they don't have to build them from the ground up. They just find ones that are already going on that make sense to them, and they join them. So that's sponsoring a case. The third way to participate is intervening in a case. This means an organization or a group or what have you can effectively, I use that term sort of knowingly, effectively become a party to the litigation after the case is already in the legal system. Okay, so this is not sponsoring and it's not a test case, but they actually become part of the litigation after it's already ongoing. It's a little bit of a combination of a test case and a sponsor case, but there's some pretty specific legal rules that have to apply when intervening in a case that don't at all apply to testing or sponsoring a case. So there's just sort of two ways to intervene. The first is as a matter of right, and that's per Federal Rule of Civil Procedures 24A. And what that means is if a group can show that it's authorized to intervene under some federal statute, so that is Congress passed some law that says groups like this are able to intervene, they're allowed to, or if a group is able to show that they have an interest relating to the property or transaction that is the subject of the action. So basically, if they're going to be directly impacted by the litigation, they can join it. So if the outcome is going to directly impact them, they can join it. But what also has to be true is that the interest of the party in the litigation isn't going to help them. Right? So basically what's going on here, if somebody wants to intervene or if a group wants to intervene, they have to show that the outcome is going to impact them, but the party to the case isn't representing their interests. So they're going to be adversely affected even though they get directly impacted. Okay, if that's true, they can be part of the case. So they can be a named part of the case. Now, so a little bit more about what that means in a moment. The second way to intervene is not as a matter of right, but it's by having a claim or defense that shares with the main action a common question of law or fact, and that's Federal Rule of Civil Procedures 24B. So basically what that means is if they have sort of a very similar question, they can also ask it, but they don't have to go through all the sort of rigmarole of Rule 24A of proving that it's going to impact them and that the current litigant doesn't have their interests in mind. So what I meant by if they intervene, they sort of become a full party to the litigation. They have the same rights as full litigants, right? They can introduce new arguments, they can make unique arguments, introduce testimony or evidence, things like that. But that also means they have to abide by the ruling. That's not so surprising because they wouldn't join if they didn't think the ruling was going to affect them. Importantly, this basically never happens. This is kind of a high burden, right, showing via 24A or 24B that you can intervene. Groups really don't do this. Long story short, this is sort of a very uncommonly invoked way for a group to join litigation. The most common way, as I think you would expect then, is filing amicus curiae briefs. Right, remember that's Latin for friend of the court. And to file an amicus curiae brief, you have to be a third party, so you're not a named party on the litigation. This is far and away the most common participatory technique. Groups file a brief advocating a particular position. A lot of times they discuss why the justices should take a case. We've already talked about this in this semester. There are 2 points at which a group can file a brief. The first is at the agenda setting stage. In that instance, they would urge the justices to take a case or maybe not to take a case. The second point is after that case has been taken, they can file one on merits. So they would discuss why the justices should take the case in the circumstance of agenda setting. They talk about potential legal outcomes, precedents that the justices should be implying, implications that they may not have thought of. Anybody is allowed to file an amicus brief. Private groups have to obtain written permission from the parties to the litigation to file. Parties almost always agree. If one or both of the parties don't, the court can, the group can ask the court if they can file, and the court almost always agrees to this. It's like 99% of the time, seriously. So even if the private group doesn't obtain written permission, they're pretty much allowed to always participate. Federal, state, local, and other governments do not need to ask this permission. They're always permitted to submit an amicus brief. Even though everybody can submit one, these briefs have to meet sort of certain standards, certain criteria. They have to expressly advocate a position, like in so many words. For instance, they might have to say, we think you should overturn the lower court ruling, right? They have to be very explicit about what their position is. They also have to present new information or new points of view. They can't just reiterate what the attorney's briefs say. And these are according to the Supreme Court's own rules. The rules explicitly state they are able to discount or disqualify briefs that do not present novel information. What this means is that a third party shouldn't just write, hey, we agree with the petitioner, which would kind of be silly anyhow because these are not free to file. They're pretty expensive, so it would be a waste of a lot of money to present a brief that didn't urge a new position. In fact, the court so adamantly wants them to present new information that they changed the due date for amici in 2007. Prior to 2007, amicus briefs were due the same day as the legal briefs. Nowadays, the last 11 terms, the amici are due 1 week after litigant briefs. That gives the writers of the amicus briefs the opportunity to read the legal briefs and make sure that they're not making the same argument. Another thing, not so recently, that the Supreme Court changed is 20 years ago, they made it so every single amicus brief that has filed has to reveal if the litigant attorney wrote it or wrote even part of it, as well as who contributed money to it, especially if the litigant's law firm paid some money for it. The reason for this is because they don't want amicus briefs to be a workaround for page limits in the legal brief. So the legal arguments can only be so long. They don't want attorneys who go over that limit to just supplement the argument with amicus briefs. Perhaps I should have said this at the very beginning, and I apologize for not, but the Latin version, singular, is amicus, and the plural version is amici. So the I replaces the US, kind of like alumnus and alumni. So sorry if you've been confused on that point. So let's talk briefly about the history of amici. The first time an amicus brief was ever filed by an interest group that wasn't a government was in 1904. Of course, that seems like a long time ago, but that means there was, 115 years of Supreme Court history without a single non-government amicus brief filed. Since then, especially nowadays, they're a very important and common part of the legal process. There's amicus briefs all along the way. They're frequent and often, and there's just a lot of them. We'll talk about that a little more in a second. So even in the first half of the 20th century, as they were becoming more common, they still weren't in every case occurrence. Since World War II, there's nary a case that doesn't have any amicus briefs. One reason for this is because a lot of large interest groups started participating more and more, and there was more large interest groups. Examples of large interests that are what we call sort of frequent flyers at the Supreme Court are the American Civil Liberties Union, Farm Bureau, the aforementioned NAACP. There's plenty of unions, state governor groups, things like that, all these different interest groups that frequently participate. So let's look at amicus participation from 1946 to 2006, which is what we see if you follow my cursor here across the x-axis. And on the y-axis here, we have the percentage of cases that have at least one brief. Obviously, 0 to 100 is the scale here. In the post-World War II period, it was pretty steady at about 23% or so. Shoots up a little bit in the early 50s, kind of comes back down. But in general, we see this linear trend over the last 60 years or so. This is a pretty huge increase from the mid-20s to nearly 100% of cases with at least one amicus brief. From 1940 to about 1960, it was like 23% of the cases. It shoots up immediately to 31 and shoots up even more to about 44 in 1969. Nowadays, it's 98% of cases. So in 98 out of 100 cases, there's at least one amicus brief filed. You got to remember, the court hears like 80 cases a year. So we're talking, in some years, fewer than one cases that have 0 amicus briefs that are filed. That's a lot. So that's it over time. That's the number of cases that have at least one. But what about the number per case? Has that increased as well? And that's what we're looking at here. The x-axis is the same, 1946 to 2006. The y-axis now is the average number of briefs per case. And there's a similar increase over time. So the previous graph showed that there's more cases with participation. What this is showing is that there's more participation per case. Until about, I don't know, the late 1960s, if you follow my cursor, there was only one amicus brief per case on average. This shoots up by 1990. It's like 4. Nowadays, it's 8, 9, 10 amicus cases per year, per case. Given this, that's a lot of reading for the justices to do. In addition to the 2 legal briefs that are filed in every case, the lower court outcomes, now they're getting 7, 8, 9, 10 amicus curiae briefs per case. It's no wonder that the docket is ever shrinking. I think this is one of the reasons that we see smaller workload. Each case just takes much more work than it used to. Okay, let's look at amicus participation by issue. Here on the y-axis we have the percentage of cases with amicus briefs. And if you follow me here, if you find my cursor, if you follow me along the x-axis, here we have all the total number of cases. Here we have civil rights, economics, judicial power, federalism, federal taxation. The different colored bars refer to the Chief Justice at the time. And long story short, what we see is that amicus participation happens in all issues, right? So the participation is not driven by a single issue. But we also see that there are increases over time in all issues, right? So with exceptions like federal taxation, in all instances, the Roberts Court has more amicus participation than the Rehnquist Court, than the Burger Court, than the Warren Court, than the Vinson Court. Okay. Obviously, this participation is higher and sort of increased a little bit more in areas like federalism here and civil rights here. It's more there than in like taxation. Okay, so again, there's amicus participation in all issues, and it's really high in all issues nowadays. For the Roberts Court, the 3 terms for which there's data for this figure, in every single federalism case they heard, there was amicus participation. Similarly, it's always above 90% except for federal taxation for the Roberts Court. Okay, let's move on to the question of who participates. Okay, there's a bunch of different types of groups that participate. Right, like I was saying at the outset, people hate interest groups. It's sort of like a bad word when it comes to politics. But for the court, or for the judiciary more generally, it's not just these moneyed interest groups that are participating. For instance, in 1995, corporations were only on 12% of the amicus briefs. Right, so that's not very high, given that when we think interest groups, we think, oh, it's just, these big groups throwing their money around, sort of flaunting their privilege. That doesn't seem to be what's going on in the court system. Instead, so it's not like lobbying in elected politics, right? It's a diverse bunch of groups. You have public advocacy groups, public interest law firms, these ad hoc collections of people. You have congresspersons at all levels. So you'll see somebody from U.S. House of Representatives or maybe a state senator file a brief. You'll see states do it, academics do it, police. All these sorts of different groups participate. And a lot of times it's individuals. It's not collections per se of those people. One way to highlight sort of who participates is to look at a case where there was a lot of participation. So let's look at the types of people who participated in D.C. versus Heller, a 2008 case, one of the biggest Second Amendment cases of all time. So here, if you'll follow my cursor, we have the type of individual who participated. The second column here is the number of briefs, and the third column is the number of amici. What that means is the number of friends, right? So that's the number of people. So you can think of that as like, here is the number of briefs, and here is the number of signatories to that brief. So what we see here is that individuals make up a huge number of the briefs filed. So 24 of the 67 total briefs came from individuals. So that's 35% of the briefs were from individuals, but 70% of the signatories, so 672 of the 951 signatories to the amici in D.C. versus Heller were individuals, by which I mean academics, district attorneys, members of Congress, state legislators, stuff like that. Okay. It's mostly, though, public advocacy groups. So groups like the NAACP, American Hunters and Shooters Association, right? They comprise 49% of the briefs, but only about 17% of the signatories. So what I kind of want to highlight is that even if we have, again, this sort of pejorative idea of interest groups dominating politics, what we see here is that in terms of people or sort of individuals participating, it's mostly individuals. It's not just these big groups. Lots of different individuals take part here. But one thing that's really interesting is that not a single corporation filed a brief in D.C. versus Heller. And you would think that, especially for like gun rights, you would have gun makers participating. But as it turns out, they're not. So we see all these sorts of institutions like unions, like the NAACP, the NRA, all these groups participating, but no corporations. So let's sort of wrap up with whether groups have an impact. There's tons of interest group participation in the judiciary. Okay, the question is whether or not it matters. Are they just sort of participating for their own health, or are they actually influencing the justices? And we're not really going to take a look statistically here. I'm just going to summarize some of the findings. Importantly, the main purpose of these briefs is to provide information to the justices that they may not already have. So given that information, I'll let you sort of draw your own conclusions about what having an influence or what having an impact might be. We know several things to be true. One, at the agenda setting stage, Petitions for a writ of certiorari are more likely to get granted when there are accompanying amicus briefs. This is true even if all the amicus briefs are saying, here's why you shouldn't take this case. Okay, we talked about this way back when we did agenda setting. What this means is that participation signals to the justices that a case is important. At the merit stage, the litigant supported by more amici is more likely to win. One reason for this is that there are more legal arguments for the justices to use. So if the respondent has 10 supporters, and then you include the legal brief, that's 11 potential legal arguments. Whereas if I don't remember if I said petitioner or respondent, but if the other side has only the legal brief, that's only one. The justices are more likely to find a compelling argument out of 11 potential legal arguments relative to just one, even if they already have a predisposed policy agenda. Finally, in regards to application to the law, amicus briefs are cited in 28% of opinions, and they're directly quoted in 9% of opinions. So as we've discussed, when it comes to opinions, perhaps the sort of plagiarism is what influence looks like. Amicus briefs are directly quoted in 9% of opinions. So altogether, we see at the agenda setting stage, at the merit stage, and at the opinion writing stage, there is some influence of outside group participation in the judicial process. The court system is just a useful avenue through which groups can achieve policy success. So it makes a lot of sense that they want to be involved, and they have plenty of ways to do it. Nevertheless, participation is relatively new. It's only about 100 years old. 1904 was the first non-government participatory endeavor, and has really only been common for about 50 years. Again, as we just discussed, participation matters, right? So it influences several stages of judicial decision-making. One thing we know about the Supreme Court justices is that they're sort of hoarders of information. They want as much information as possible to make their decision. And it seems that the more information they have, sort of the more they're able to draw on that information, unsurprisingly. So it comes as no surprise that these groups, any outside interest group, jumps at the opportunity to provide them some of that information. But again, I come back to this sort of thing we hate about interest groups, the insidious advocacy, right? The kind we hate in Congress, doling out huge amounts of cash, sort of buying votes. That doesn't seem to influence the judges so much. And a reason for that is because that's sort of not the type of participation that's going on. One reason that groups like gun manufacturers may not have participated in the Heller decision is that maybe they thought, even if they had a totally unbiased opinion on the Second Amendment, that the justices would discount it as economically motivated. I don't think any groups worry about legislators believing their intentions are economically motivated. So maybe these groups just sort of think about the judges, the justices, in a little bit different way than they do other political figures. So one thing that I'm going to leave you with for you to mull over before we meet Monday is whether interest groups deserve this scrutiny when it comes to the judiciary, right? People hate interest groups, and I'm wondering whether you think they deserve that scrutiny in regards to the judiciary. They do have an influence. Maybe it's not just a moneyed influence, but they do have an influence. So outside groups that are not party to the cases and controversies that bring suits before the court do have an influence. And I want you to think about whether or not we should hate them for that. All right. Thanks for tuning in. Hope you have a good weekend. I'll see you Monday.